going there. And one was exposed for the first time to what they call the Socratic method of teaching, where the students, engage as much as, if not more than, the lecturer in the learning process, which is something I think we could adopt in South Africa. I remember that when I returned to the country, I went back to plow back at my alma mater, the University of Transkei, and I tried to implement that kind of teaching, and the students, most who were older than me, just didn't take kindly to it. They didn't understand that you had to prepare thoroughly before you attended class, and took an active part in the proceedings during the classrooms. They expected to just go there, sit, and have me give them material that they will take down. So I was exposed to the Socratic method of teaching for the first time, and the culture shock, which everybody who's spent a significant time away from home will attest to. Everything was new. You walked into a grocery store and you didn't see any familiar brands. You had to start, you were looking for Omo and sunlight and black sky and all those things, and none were there. And these things we take for granted, but they can be, being in an unfamiliar surrounding can be very alienating. But as I say, I was young in that lecturers, and I quickly got into the swing of things, and I managed. I even met my husband there and came back with a baby. So it was a fruitful undertaking.
Yes, I hear you talk about the Socratic method of teaching. I can tell you that at my university, University of Zululand, when we were doing junior degree, it caused a huge problem. There was a lecture boycott because of a lecturer who came and tried to apply it. There was a lecture boycott. So it was not very popular, but maybe over time it might have become popular. Let's move on and talk about your time at the bar. What can you share with this commission in terms of your experience at the bar? I'm skipping your earlier experiences.
It was not easy, Chief Justice, and one is dismayed when we interview candidates here at the JSC who come from the bar and hear them still, narrate experiences that are my experiences, things that happened to me all those years ago. Being a woman at the bar was and is still hard, as we all know. And the main issue is that I suppose those who have the work, who can brief counsel, do not have sufficient or any confidence in women. I did my privilege in the Johannesburg bar, and I did exceedingly well there. I remember you were called for an oral after the examination, and I was called, and my master mentors were called masters then, whispered in my ear that they were just curious to meet me because I was this young black woman that not many people not many black women had been overseas at the time. Had attended an Ivy League university as I had. So I was just asking questions in that oral examination, and questions similar to what you just asked me to explain how I found America and the like. So I did very well with my privilege, and you would expect that someone who was able to quickly grasp, the workings of that part of the profession would have got some work. But I soon realized that there was not going to be any work for me. In fact, I saw, just observing the black advocates who were seriously struggling and got most of the work.
Yes, and of course, you have been on the bench now for over 20 years.
It's 22 years.
22 years.
Next month.
Yes, yes. Well, I was reflecting a few days ago and thought, on a light note, it looks like you and I have been trying to be in the same court for quite some time, because way back, I invited you to act in the labor court and you agreed. And when I wanted to invite you to come to the labor appeal court, the SA had grabbed you. And you would I think you said you would have loved to come, but they grabbed you. But since then also, we were interviewed for the ConCourt in 2009, together with many others, and 2011. So it looks like we have been trying to work together to be in the same court.
Yeah, I would agree, CJ. And on that note, I just want to commend you, in fact, for inviting me to the labor courts back then. And it's something I and those who got the privilege to be invited to go and work in that court for the women, that is, we always whisper, well, not whisper, we gossip loudly, that you are actually one of the judges president who saw the need who had the necessary respect and confidence in women, and saw the need, the urgency to diversify your court, the labor courts then, and you invited a number of women to act in your court, and I mean, that experience was invaluable, and for some of us led to other avenues, bigger avenues. And I just want to thank you for that, because not all male leaders have that inclination to give women a chance, and I hope that it's something we will continue doing until we leave the judiciary as we try to transform the institution.
Yes, thank you very much. Thank you for that. And of course, you did act in the Constitutional Court in 2012. Do you just want to share your experience with the commissioners when you acted in that court?
It was a very enriching experience, intellectually and otherwise. I found all judges who came from the SCA to act in that court always commended it for its collegiality, because it's something that did not quite enjoy in our own court at the time. So it was a pleasant experience, intellectually, highly intellectually stimulating, and I managed to get in a couple of judgments during my short acting stint there, but my faith was not in that court at the time, so I went back to the SCA and made my name there for myself.
During the time, your acting stint, I would imagine that you would have got exposure to dealing with cases where legislation was being challenged as unconstitutional.
Yes.
Is that so?
Indeed, and it's the kind of work one has continued coming across, even where I am. Just a week ago, we delivered a judgment which I listed actually in I think it's paragraph 65 of my application form as a reserve judgment, but it's since been delivered now. The case of the Minister of Culture, versus British American Tobacco, one of the so-called COVID cases where the regulation made by the minister which banned smoking during the pandemic was challenged, and we ended up applying the Section 36 proportionality analysis, dealing with issues such as procedural rationality, and all these issues that the Constitutional Court deals with more often than the other courts do. So I am familiar with that kind of exercise.
And you would, did you get a chance of, did you get cases where you had to do reading in and reading down, those kinds of issues?
No, I have not had that privilege,
Okay.
But I know what those concepts are.
Yes, okay. Thank you, Justice Meyer. Minister?
Yeah, thank you very much, CJ, and good morning, President Meyer.
Good morning, Minister.
Yeah, my question relates to what do you see as your role as a Deputy Chief Justice in helping the administration of the court and also of justice in general within that space? Thank you, Chief Justice.
Thank you, Commissioner Muimang.
Thank you, Chief Justice. Good morning, Commissioners. Good morning, Judge President Maya. Just two questions from my side. I think in the book one, the one that talks to the nomination, amongst the papers that we presented is the role of the judiciary in protecting the rule of law. I think it's a paper that we presented in 2019 at NADEL. It is on page 26. Can the Judge President just share with us what is her appreciation that she shared with NADEL AGM on that day, particularly taking into account the critique and the criticism that the judiciary has recently faced. I'm raising this point because the Constitution in Section 1 talks about the need to promote the rule of law, and Section 2 talks about the supremacy of the Constitution. At the same time, Section 165(4) talks about the need for other organs of state to respect the independence of the judiciary. Thank you, Chief Justice. That is the first one. Yes.
Okay. My answer in short, Commissioner, would be that the role of the judiciary is to protect it is the same that is shared by all South Africans, state organs, individuals, and so on, to protect and enforce the Constitution, and there is the additional task for courts to interpret its provisions. And that is basically what courts do in a nutshell, and that is what I believe our institution has been doing all this time through tough times.
The second one, Judge President, relates to now the book one that talks to the feedback from law bodies on page 19, which illustrate the performance of the Supreme Court of Appeal under your watch, which must be appreciated, because clearly that is an illustration of the good work that you have been doing in providing leadership. However, the area that I want you to talk to relates to the challenges that were raised by the Office of the Chief Justice in relation to the two matters that landed on the table of the Chief Registrar in the Supreme Court of Appeal. And the impression that came from the statement released by the Office of the Chief Justice was that that office is riddled with challenges, which was sort of a concern to me, given this excellent work that you are doing. What is it that you have done to correct that area, so that as you leave the Supreme Court of Appeal to the ConCourt, there's no repeat of such an issue again? Thank you. Thank you, Chief Justice. Thank you, President Maya. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Singh.
Thank you very much, Chief Justice. Good morning, colleagues. Good morning, President Maya.
Good morning, Commissioner.
Good to see you, even though virtually.
Yes, indeed.
Well, there's two things I've learned today. One is the phrase gossip loudly. I never heard that one before. And the second thing I've learned is that you are attached to the hip in a judicial sense with the Chief Justice. And I don't believe there's any way for us to try and break that attachment. But President Maya, my questions relate to your answer on the role of the Deputy Chief Justice, if you are appointed. And I think one of the roles is to have strong communication skills. And that would be in regard to maintaining public confidence in the judiciary. Now, from Afrobarometer survey, and I think I asked you this question the last time, it seems that public confidence in the judiciary is waning. Now, how would you, if you are appointed as Deputy Chief Justice, play your part in contributing to public confidence being accelerated in the judiciary? Thank you. Thank you. That's the first question. Thank you, President Maya. I see you're going to play an active role in that regard, which is very good. My second question relates to the three areas that you identified as your vision when we interviewed you previously. And one of the areas you identified was gender diversity. And I do know in that interview, I also asked you how you felt about the fact that we had just concluded interviews for the position of two judges at the Constitutional Court. And whilst we respect the President's prerogative to appoint people to that court or any court, it was unfortunate at that time that two males were appointed and no females, and there were two very capable females in that lot that we recommended. But soon after, there were two other vacancies, and yet again, the President chose to appoint a male in that position. Now, I understand that the ConCourt has 6 males and 3 females at the moment, and things could change with the vacancies that exist. But you are a gender activist. How do you feel towards transforming the judiciary in terms of gender activism? And like I said, I want to emphasize it's the President's prerogative to appoint people, and he can accept or not the recommendations of the JSC or political party leaders. But how did you feel the second time round when a male was appointed by the President? And what role will you play in the future to ensure that gender activism is not only seen to be done, but must be done? Thank you. No, thank you very much, President Maya. We hear you and we hear you well. Fortunately, this time around, your nomination has come from the office of the President and from the President himself. Thank you, Chief Justice. That's my two questions. Thank you.
Thank you, Commissioner Singh. Commissioner Mapisa-Ngagula.
Good morning, President Maya.
Good morning, Commissioner.
It's good to see you, but it's not good to see you on a virtual platform.
I know it's, I feel so disconnected
Right.
here, but what can we do?
Thank you very much. Judge Maya, last time when we interviewed you, one of your landmarks decision was to write a judgment in isiXhosa, and you've made reference to that earlier on. I just want to hear from you, what prompted you to do that? And how would you encourage other judges to do the same, at least some, to make sure that some of their judgments are in fact written in all official South African languages? What really prompted you to do that? Because it must have been a difficult decision. Easy because you wanted to do it, but difficult to do as well. Thank you. I think just a comment. I hope you realize what a groundbreaking decision you took for South Africans. Because, as you said earlier on, even though we recognize all 13 languages and our official languages, but South Africans continue to trample on the dignity of languages of some of our people. And because it was such a groundbreaking decision, I would urge you, urge your office when appointed, to continue to encourage. I know that it won't be possible to enforce, but just to nudge the judges in the different provinces to make sure that at least you have a few judgments which are written in other South African languages other than English. I just thought I should make that point. Thank you very much, Judge Maya, and good luck. Good luck. I don't know if I want to say good luck. It shouldn't be luck. CJ, it shouldn't be luck. I think you've worked for it and you've earned it.
Thank you, Commissioner.
You are done, Commissioner? You're done.
Just that question on language.
Okay, thank you. Commissioner, Judge President Leo.
Yes. Thank you, Chief Justice. Good morning, President Maya.
Good morning, JP. I'm happy to see that you're still around.
Yes.
For a short while.
I still have some 2 months.
All right, make the most of them.
Yes, thank you. And I wish you a speedy recovery also. I have about 3 questions, and 2 already. One, it will be like a follow-up from that one of Commissioner Singh, and the one from Commissioner Mapisa here. Mapisa Ngakula, sorry. I will start with the last one relating to a judgment in Sikosa. I take it that you have written quite a number of judgments, and one of them relates to customary marriages. You have written actually more than one on customary marriages. And the question that what prompted you to write this one, the one of AfriForum against the University of South Africa in Sikosa, and your answer is it was because of Judge Fruneman or other reasons that you have already given. Wasn't it the appropriate moment for you then to have written the judgment in an indigenous language, including Sikosa, for the purpose of the parties, and that, I mean, a judgment on customary marriage would attract quite a number of people to know what is in that particular judgment, especially the ordinary man in the street. Because in this one, much as it was a groundbreaking judgment that dealt with languages, it was AfriForum. I would think appropriately it would have been better been in Afrikaans, because it related, it addressed the people who would have an interest in reading it would be those who are in reading Afrikaans. And that is my question. Why wouldn't you have had a COSA judgment in cases like the customary marriage cases? Number 2 is also related to that.
Can I answer the first question?
Oh, okay. Thank you. I was not done with the first question. I was,
Right.
what I was,
Just say the second question, I'm sorry.
no, it's not, I'm still with the first question.
Okay.
Yes, the heads of court decided that the language of record will be English, and you were part of that heads of court decision. Now, when I said you interrupted me, I wanted to say, in a panel of judges, you'll find that not all judges will understand a particular indigenous language, but the language of record would be English. Now, you translated the English judgment to Xhosa because you understand it better, but not all the members of the panel would understand that very same language. So the correct procedurally, wouldn't it have been that you would have to employ a sworn translator to translate the English judgment into Xhosa, and it would not have even limited you only to Xhosa and had caused you to work much on that particular judgment, but you would have got someone who, after translation, would certify that what you and all the judges said in that particular judgment was what is contained in this indigenous judgment, because it needs someone to certify, like a sworn translator to do it. And in that case, it wouldn't have only catered for Xhosa-speaking litigants or members of the public. You would have done that in respect of all the official languages using a sworn translator. And it would not have taken long, perhaps, longer than you had anticipated, as you say in the previous interview. Wouldn't have that been would have provided for everybody all the languages, because right now I am of the view that the Shangans and the Tswanas and all of them have been deprived of what is contained in that particular judgment. Yes,
I don't want to get into issues of budget, because there are issues of practicality as well. If there's going to be a policy,
I'm sorry.
So, Commissioner Malema?
I wanted to make a follow-up when she's done.
Okay, okay, all right.
Not you,
The Judge President. Yes.
CJ, can I just correct? People keep referring to me as Judge President. The SCA head of court is a president, not a
Yes,
judge.
you are right. But this one is Judge President.
Yes.
Yes, yes.
I'm sorry.
Are you done?
No, I'm not done. I still want, why I'm interested in this question is President Maya will be in a leadership position where policy eventually for the judiciary will have to apply. And right now, I don't want you to look at it in a subjective way, but to look at it in an objective way. I am sure right now, you must think of you are in the SCA and you are not in the province like provincial where I would cater for the Tswanas or, regional. But what my question is, when you are appointed in this position, how are you then going to be in a position to cater for all the 13 or 11, I heard you speak about 13, but 11 official languages that surely, much as you have done it for yourself, but with the budget constraints that you were faced with, I'm of the view that it would have been more ideal that when you got that sworn translator, and I'll tell you why I'm talking about it, sworn translator. If I translate as a judge, I may not be saying everything that the whole panel is saying. We are not sure as to whether in this other translated judgment that you wrote exactly what your other colleagues were saying in their judgment. But a sworn translator is sworn and trained that whatever is said is going to be the truth of what was said by the whole panel. So I'm not saying you are doing it, yes, you say you are doing it for yourself, but my view is it would have been better if it had catered for all the languages. And my question is that what you intend implementing now, when if you are appointed in this position that you will be having the code of record or a judgment that will be in English, and then all the 11 official languages will be provided for? Yes, I'm moving on to the second question, which I say is also a follow-up. The Judicial Accountability Committee, which is a subcommittee of the heads of court, the rationale behind having that committee was for judges to account to the people of South Africa about their performance, as well as how the courts are operating and so on. That is in addition to what they say in their judgments. So the question asked by Commissioner Singh was, the judiciary is put in, in a negative light, and I should think you also remember that that was the reason why the Judicial Accountability Committee was established, in order to, say to the nation or the people of South Africa that this is what we are doing. This is how all the courts, from the lower courts to the highest courts, are performing, and also to say what the challenges are and give ourselves targets. So that particular committee, in actual fact, was trying to put out the image of the judiciary to the people. Why I'm raising is it correct? You remember you were the chairperson of that particular committee, and after several months without calling a meeting, you then phoned to say you cannot serve in that committee, and you can't even be the chairperson of that particular committee. Is there any particular reason as to why you did not want to serve in that committee? Thank you. I didn't say you did not support the initiative. My question was chairing.
That's the question.
Yes.
Yeah.
Okay. Can I move to the last question? There is this case of Standard Bank versus Tobejani. This matter came from the full bench of the Gauteng High Court, and it related to a situation where most of the litigants who had entered into contracts with the bank would be in arrears, and banks would approach the high courts for foreclosures. And in most of these cases, you would find that in the contracts, there was an agreement that the jurisdiction of that particular matters or of those particular matters would be in the magistrates' courts. But the bank or the banks would not go to the magistrates' court. They would rather take the matters to the High Court. And that entailed a litigant having to pay counsel to appear for them in the high courts. And secondly, you would find that most of the indigent litigants would not afford to go to the high courts, mainly sometimes because of distance. For instance, if you are in Rustenburg, you would not be instead of going to the magistrates' court, as per agreement, you were forced to come to Mabatu in order to deal with those matters. So that matter, the full court in Gauteng decided that no, matters should go to the lower courts because of that they were clogging the high court rolls, and because in any case the agreement was that such matters would go to the magistrates' court even though the amounts were above the jurisdiction of the magistrates' court. Now, my question here is, because of the high court decision in Gauteng, almost all the high courts would postpone their matters because now we were waiting for a decision from the SCA in relating, because there was an appeal against that decision. The banks had appealed against that decision. But now the matter was heard in the SCA on the 20th of August 2020, and the judgment was handed down on the 25th of June 2021, which resulted in all these matters that come from the banks not being finalized. And eventually, it would seem the matter, you had allocated the matter to yourself, but then after December 2020, the matter was now allocated to Deputy Judge President Sutherland, who had already left the SCA because he was acting there, and it was allocated to him after December. And that also now caused a longer delay. Can you perhaps explain as to why this matter had to take so long and which had so much interest, especially the interest of those litigants whose houses ran the risk of being sold because they had to go to the high courts? Thank you.
Thank you. Commissioner Malema, you wanted to do a follow-up?
Thank you, Chief Justice.
Thank you, Commissioner Malema. Commissioner Nyambi.
Thank you, CJ. Morning, President Maya.
Good morning, Commissioner Nyambi.
I've got 30 questions, but because of time, I'll ask you one.
Yes.
On a serious note, the scourge that is facing our country, President Maya, the issue of gender-based violence and femicide. We have had a number of summits as Parliament, even yesterday on a Sunday, because it was a Father's Day, we decided to have a session so that we can be conscientized to assist the country to deal with that problem. And I've seen that the presidential gender-based violence and femicide summit that was held in Pretoria, you also address it dealing with the issue of judicial and legal responses to gender-based violence and femicide. My question, as you aspire to be the second in charge in the judiciary, what is the critical role that can be played by judiciary to address this scourge that is troubling our beloved country, South Africa? President Maya. Thank you, President Maya. Thank you, CJ.
Thank you, Commissioner.
CJ, can I follow up, please, on
Yes, okay.
Thank you, President Maya. Mine is just a follow-up on what Commissioner Nyambi indicated. I think I was humbled by your publication, the same that Commissioner Nyambi has referred to, the judicial response to gender and based violence. And in that you indicated that there should be a standardization of and formalization of norms in the treatment of victims. I just wanted to understand whether, and this very publication has been cited in the UN, you know, yes. But I wanted to know whether the standardization has been done and what did you have in mind that can actually assure the victims that their matters are being taken care of. Follow up, President, has the standardization, do you intend proceeding with it? Because for me, I think the issues that victims feel done under by our system, I think it's a good idea, it's a good approach, but I will urge you to actually follow it up, you know, and then make sure that those standards are there to enhance how the victims, you know, are treated and how to appease, actually, not to appease them, actually to assure them that something has been done. Yeah.
Thank you, Commissioner. Commissioner Makonishi.
No, thank you very much, CJ. Good morning, President. Good morning, we wish you a speedy recovery. I've got one question. How will you transition from being a head of an institution to be a deputy head of an institution? The supplement to that question, how will you lead upwards and downwards? How will you lead upwards and downwards? In some respects, you will be required to lead your colleagues as a Deputy Chief Justice. In some respects, you might be required to lead the Chief Justice.
You're done, Commissioner?
I think the operative question is how.
Oh, okay.
Thank you, CJ. Thank you, President.
Thank you, Commissioner. Commissioner Matolo Lepu.
Thank you, Chief Justice. President, the only question that I had, a direct question, is in your last interview, you promised to put in a harassment policy as of today. Have you done that? Just assure me.
It has not happened.
Thank you, CJ.
Thank you, Commissioner. Commissioner.
Justice, President, may I ask a follow-up, please?
Yes, go ahead. Thank you, Commissioner. Commissioner Baloyi.
Thank you, Chairperson. Good morning, President Maya.
Good morning, Commissioner.
President Maya, I have two questions, and I would like to frame them as questions that intersect, questions of accessibility and of access and transformation. I beg your pardon. Now, the first one is about language, and there's a way in which it is a follow-up on the discussion that has happened. Now, is it not so, perhaps, that if the question of language is framed as a question of access, and access to the courts, but also to our judgments, making judgments accessible to members of the public, but also litigants and their legal representatives, that if it is framed as that, then it ceases to be about the personal preferences and biases of judges who write judgments. So that instead of it being left to, it will be another 5 years before we get a Sutu judgment or a Tswana judgment, because some other judge is motivated to support or to write in Setswana in order to develop the languages, that it becomes an imperative for role players such as heads of court, the Department of Justice, the Rules Board, and everybody that is involved in matters such as this. And so it elevates that discussion, and you are able then, as head of courts, to make commitments to the public on which we can judge you. You know, in the same way that in your last interviews you had made commitments, then you can make commitments to say, here's where I will be, or I hope to be, in 5 years from now. Isn't that the correct framing of this issue?
That's a very useful insight.
And it seems to me, Justice Maya, that if that is how it is framed as an issue, that then you sort of also naturally get to the position that J.P. Leo was proposing, that perhaps then you get to employ translators to translate judgments into the different languages. Isn't that something to look at?
Yeah.
All right. The second question, again, I think it's about transformation and access, at least I think it intersects that. And it's about the use of technology. Now, we were dragged into using technology by COVID, virtual appearances and filing of papers, and one is mindful of the problems with case lines now, the publicized difficulties with it. But speaking about appearances, virtual appearances, something that was not planned, part of a plan to drag us into virtual appearances. But we find ourselves there, and it's almost a cliche to say that COVID has changed our lives forever, and we have learned new ways of doing things. However, the experience is that even, you know, at the difficult times of COVID, but today, you get resistance from some judges about virtual appearances. And so you would have judges, some judges insisting in-person appearances, And recently, with the lifting of the state of disaster, some courts have gone back to physical appearances, and your court is one of those that have gone back to in-person appearances. Now, the one advantage or benefit, I thought, of virtual appearances was that you get members of the public being part of your court processes. And I've had the experience of a matter where there were 100 attendants on the platform because the matter was of that kind of interest. And yet, physical appearances limit that kind of access. Should we not be looking, instead of regressing on things like virtual appearances, in fact, be promoting them even more? And is the failure to do that an indicator in any way of some level of conservatism when it comes to using technology?
Again,
Thank you, Judge. Thank you, Chair.
Thank you. I've been advised that the plan was that we, excuse me, we would take our tea break at 11 o'clock. Shall we take it? And is it 15 minutes? Yes. Okay, let's take a, so it's about 3 minutes past. Shall we say we come back at 20 past? 20 past.
Thank you.
Thank you.
Firstly, I must say we are fortunate because we have a brand new Chief Justice from the box, and we'll have you brand new from the box as the deputy. But this is a matter which is a concern. Now, the other question, as you leave the SCA, there is this thing of reconsideration after, say, a leave to appeal has been dismissed, and then there's an application to the president for reconsideration of that. And I'm sure often we have done those. The next president will do those. The question is, do you really, I know the law, I mean, is passed by Parliament because it's part of the Act, but is there any relevance for that section? Do you find it helpful in terms of court practice? Because I've tried to say, how many cases are you aware of where the SCA has overturned a decision of the judges that have refused a leave to appeal?
Thank you so much for raising this question, Commissioner Jesse, and I'm happy that Minister the same case and circumstances. And it was conceived that it's just from that example, and there may be other cases where an injustice may occur if things were left on I mean, there was no recourse that a person in the place of this example I've given found themselves, if there was no recourse in the statute books, that they could engage. So that was the reason this provision was enacted. But unfortunately, there have been unintended consequences, severe unintended consequences that almost every litigant now whose application for leave to appeal is refused by the two judges of the SCA wants a second bite of the cherry, and they apply for reconsideration. And I am literally flooded by those applications. And DP Pese will vouch for me, because when in my absence and when he acts as president, the task has befallen him to deal with them. I mean, there are weeks where I get as many as 12 applications for leave to appeal, and it's just burdensome. So soon after my appointment as SCA president, I wrote to Minister Masota. I sent him a well-motivated memo asking for a repeal, an amendment, or just to make it discreet, to deal with discrete cases. Amendment of the provisions, just their total repeal, because for many years, the sky did not fall in, they did not exist. to this day, I don't know how many reminders my office and I have sent to the Ministry of Justice asking, you know, what the status of my request is. And it's almost, 7 years later, no joy, nothing is, well, like, as far as I know, nothing has been done about it because I've not received a satisfactory response. And when Minister Masuta left, I carried on and tried to prevail on Minister Lamola to assist. I'm still waiting to hear from him.
Lastly, Chief Justice, on your last occasion, President Maya, you made a profound statement when you say you would not like to be appointed to the position, then the Chief Justice, but I think by extension this one, simply because you are a woman, but because you are a competent woman that is available for the position. That was a profound statement. And I want to comment that the second, and also in line with the theme of the question of your debate when you're dealing with the question of gender diversity. What I want to put across here is I didn't understand the debate about this issue of languages, the rhetorics, because here is a woman first writing a judgment in an indigenous language where no one has thought of. And what I want from you, when you look back, reflect when you decide to write that judgment, would you say you did the right thing? Thank you.
Of course, I did the right thing, Commissioner, and that's all I will say to it.
Thank you, Commissioner Notesi. Commissioner Lucas.
CJ, Lamola.
Commissioner Malema.
Lamola.
Oh. I apologize.
Same WhatsApp group, don't worry. Same WhatsApp.
Okay, you want to follow up?
I thought I'm more handsome than Commissioner Malema.
I apologize. Okay.
Now, it's on the first question by Commissioner Nojesi. I confirm that indeed the President of the Supreme Court of Appeal did raise this matter with myself, and I referred it to the legislative drafting unit of the department for their further processing and consultation. I'm not sure if it's also the same matter that the Deputy President Petse also raised with me, but I know that it is being processed in the legislative unit. But I get the concern that it has taken too long, but it is being processed. Thank you, CJ.
Thank you, Minister.
Thank you for the update, Minister. I appreciate it.
Commissioner Lucas.
Thank you very much, Chairperson. Good morning to everyone, and good morning to President Maya. Now,
good morning, Commissioner.
One thing, Chief Justice, if you are at some of the last ones, almost everything that you wanted to ask have been said. So it became very difficult to still be able to ask anything. But there is some of the areas I just want to comment also. I think someone spoke about the issues of, of public confidence. Justice Maya, the experience that I'm having is that we are a very polarized society. And we are literally divided on everything that is in the public domain, and also very much divided on the issue of confidence in the judiciary. Now, when you interviewed the last time, you had this idea of a one judiciary that you put on the table. But I think I'm not asking you a question, because subsequently today in the interview, you have actually responded as to how you can make sure that there is harmony in the office of the Chief Justice between the two of you, to make sure that you also convince the Chief Justice of issues that you think that will actually work for the judiciary that will make it that will bring more harmony, but that will also respond to some of the experiences, particularly the experience of yourself as a woman. Now, I just want to quote someone, the Premier of Gauteng. Just last week we had an event in Gauteng as a report-back session of the Women's Charter, just for us as Parliament to see how far the government in provinces have come with regards to response thereto. He said something very profound, and I want to I want to quote him. He said, depriving women from equal development, or depriving women from equal development equals to minority development that is similar to apartheid. And I want to quote him, and for me it is that issue. Now, you have also shared your experience as a woman. Now, in a very short summary, as to how do you see yourself using the position in collaboration with the Chief Justice to make sure that women in the judiciary firstly, but also women in general, begin to see that the law, let me put it like that, how people are putting it, to say the law is not working for them, but that the law can at least begin to work for us as women. Because I should say, just in Gauteng alone, I had more than 1,000 women in an event in Alberton. And most of the issues is that women is just not getting justice. If you go to an area like Northwest, you still find that if a professional woman can come with a black eye, the police will feel it's a laughing matter. So that is why I'm putting this on the table. How do you think, particularly you have highlighted some of your experiences, how can the judiciary assist us to make South Africa work for women? Thank you.
Thank you for the question, Commissioner. Well, I think the first important step is what we are about here today, to put yet another woman in a position of leadership. It has been proven across the world that when you have women in leadership positions, issues that affect women, and in turn, because women, as I pointed out earlier, they comprise the largest component of any society. So when you have women in leadership position, women who have an empathy, who understand, what issues actually affect women, then things have to begin to change. And just having me in this position would be such a profound statement, and incidentally, it would assist with the other issue of a huge component of our public having confidence in the judiciary. Because when women out there see that, oh, there's a woman sitting at that table that decides laws, that the application of laws that affect our lives, then that gives them hope that they will be given a fair hearing. That's just one of the features, positive features about having women in positions of power. We are fortunate because we have, as I indicated, and I made that statement very deliberately. I meant it, and I wanted to commit the Chief Justice even deeper in what he already believes in. CJ is a feminist, if I may put it that way. We have this, most women in the judiciary, that is those who are members of the South African chapter of the International Association of Women Judges, which is a body of judicial officers, magistrates, and judges alike, and has friends. We have practitioners as well in varying capacities in the body. They know the Chief Justice as one of them, because since the time immemorial, he has always supported that body he knows the concerns. He has heard firsthand. He has contributed to the act of trying to find solutions for women in the judiciary. He is a member, he's a trustee of a trust of that women judges body, which is a big thing to have a man, you know, play such a major role in something that is owned by women activists, because, you know, that's what these women are. So we have the advantage of having that kind of a leader at the helm of this institution. And it will be an easy matter, I believe, to prevail on him, to carry on that, you know, with that approach to these issues. And he will have an open mind to all ideas and initiatives that are brought to the table that are meant to better the lot of women, I do want to believe. So those are the two advantages. First advantage is, Commissioner. This question, I believe, has been asked by another commissioner earlier in another way. Cases, but in a tiny context of GBV, the way GBV cases are dealt with, and how we ensure, you know, that they get the attention they deserve from the courts, and achieve what, you know, the decisions in those cases should achieve in society, to act as a deterrent, for one thing. I can just repeat that sensitivity, social context training among the judges and all the stakeholders in the administration of justice chain, you know, we all need that. We have, there is already in existence a body called the National Efficiency and Enhancement Committee that brings together all the relevant legal stakeholders, your NPA, police, and so on. And I'm just thinking out loudly now. It's an idea that still needs to be. I need to think through carefully. I must flesh out. But it seems to me that that is another platform where this idea of social context training could perhaps be introduced, so that the police, yes, there are mechanisms in place already to sensitize police that if you are dealing with a domestic violence case, this is how you deal. If you are dealing with a rape case, this is how you deal with the complainant, and so on. But we need to multiply the effort that is put into those educational initiatives. And as I say, speaking as a judge, that's one platform that is readily available to us to reinforce that message, that when someone comes to report that they've been assaulted by their living partner, their husband, their boyfriend, the police officer on duty does not say, go home and sort out your business with your lover, and all the things we continue to hear to this day about the, you know, terrible treatment of victims of these crimes against women and girls in our country. So those are my basic thoughts at this stage, Commissioner.
Thank you, President Maya. And I really want to wish yourself and the Deputy President of the ACA well, with the fact that it seems your bones is leaving you now. Thank you.
Thank you, Commissioner Lucas. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, President Maya.
It's still morning.
Is it still morning? Oh,
just
3 minutes short.
Morning.
3 minutes short of being
Yeah.
afternoon. President Maya, I've just got a few questions which flow from your vision that you presented during your last interview before this body. And then I'll be just dealing with a few of the objections that have been raised in relation to your candidature. Firstly, I must say, like millions of South Africans, I watched your interview at the last sitting when you applied for the Chief Justice position. And like everyone else, I found your vision so compelling President Maya, but it's only when I actually studied the transcript of your interview that it struck me that you had not only presented a vision for what you thought some of the key issues which affect the judiciary are, but you also mapped out very practical measures which you believed could be introduced in order to address some of these challenges. So the first question I have, and I think it tags on to something that Commissioner Magwanishe had raised with you earlier, is you having presented your vision and these practical tools, how do you see that aligning with the Chief Justice's vision for the judiciary going forward?
Thank you so much for that question, Commissioner. I did follow the Chief Justice's interview in February as well, and I have had occasion to hear him speak to the media about what he envisages for the judiciary going forward. And my overall impression from hearing his thoughts and views was that our visions are actually not far apart. The only point of difference that I could make out was what I proposed. Well, some of the few things I thought I proposed that I thought could work for the Constitutional Court to assist with delayed judgments and how to deal with the terrible influx of work there. But I do know I've not made further explorations into what they're up to now, but I do know for a fact that they are working hard at resolving those issues, CJ and the colleagues in the court. Most of those colleagues come from the SCA, and from my previous conversations with them, I know that they like the way they did things at the SCA because it makes for efficiency at the end of the day. So I have a feeling that if I do go there and they have not adopted some of the things I propose, I may be able to persuade them with their assistance and buy-in of the others who have not been to the SCA, persuade them to to adopt them. But some of my question is that the CJs, it won't be a difficult thing to harmonize my vision to that of the CJ because they're the same, pretty much the same.
Thank you, President Maya. The second question I had related to what you described in your vision as a single judiciary. And when you dealt with this concept, what you did is you focused on the challenges facing the magistracy. But unlike many of the other topics which you dealt with, you didn't quite reach the point where you suggested a practical way forward. In other words, what's the next step in unifying the judiciary from that perspective, including the magistracy and keeping them as close as you can to judges, so that they can also start benefiting from some of the OCJ's initiatives to, for example, properly resource courts, etc.
Well, I'm afraid I'm going to disappoint you, Commissioner, because I don't have I don't have fresh solutions. I've not developed my presentation on that issue. For a number of good reasons. Let me just say that you will remember that I was clamoring for a judges colloquium. That is where resolutions on well-informed resolutions that have the buy-in of everybody are made about our institution are made, and I lamented that we have not had one in over a decade now, since 2009. It's a sensitive issue that I would love to be debated, on that kind of platform and get as many ideas on how we can carry it forward as possible, because I know a great majority of judges and almost all, if not all, the magistrates do want a single judiciary. One practical thing I had mentioned though in February was that they should be brought into the fold. They should be brought into under the administration of the OCJ. I mean, that's the logical thing to do. And once they're in the fold, then it will be an easy thing. Well, not an easy thing. There are always budgetary constraints. I mean, it would make for a massive institution. Judges are only about 250, and you have thousands of magistrates, and one would have to capacitate the OCJ for one thing. There are all sorts of details with far-reaching consequences that would need to be addressed to achieve that. So I will leave it at that, Commissioner, and hope you are not too disappointed with my answer.
Not disappointed at all, President Meyer, but I really want to thank you for highlighting this issue, because obviously the magistracy is the face of justice for millions of South Africans, and so it needs to be prioritized, I think, from the perspective of the OCJ at the very least. The third issue I wanted to raise with you was it's a jurisprudential issue, really. One of the areas of your presentation that was slightly thin was touching on the jurisprudence which is flowing from the Constitutional Court. And I just wanted to raise one issue with you. I think in your previous interview, you spoke about the 2021 Afrobarometer survey. One of the issues which flows from that survey is the staggering number of South Africans who think that poverty is the most serious issue that needs to be addressed. And I just wanted to get a sense from you in terms of the jurisprudence and the judgments of the Constitutional Court. What do you think the court can do to alleviate the plight of so many poverty-stricken South Africans, given the fact that the Constitution enjoins government to progressively realize the socio-economic rights in the Constitution?
That's a tough one, Commissioner. Look, all I can say is that courts, and that does not exclude the Constitutional Court, can only deal with issues when they are brought before them. And as far as I know, and I think I'm 100% right in this answer, whenever the Constitutional Court has been presented with a case that deals with socio-economic issues, it has done its very best to apply the values, the injunctions of the Constitution, rather. There's a long line of cases, starting with your road bombs, even if they had disappointing outcomes. And you can't blame the Constitutional Court for that. It's the other side of the fence that did not fulfill its responsibilities. Whenever a relevant case has been placed before that court, since we are speaking about it, it has not failed. And one can just look, society, and I'm speaking about NGOs now, because they're at the vanguard of this important aspect of our transformative constitution. NGOs must do more to go out there and route cases, relevant cases that can be brought to the courts of law, which will improve the lot of our people. I know that they do a lot, but we have seen the extent of the challenges that face our country, especially our youth. And all of us just need to do more. But then I underline that courts can only deal with cases once they're brought before them. We can't go out there and demand that people bring these relevant cases to us.
Can I just follow up to that, Justice Meyer? I mean, one of the tools which the courts use to ensure, firstly, proper compliance with its orders and better realization of the rights is a supervisory interdict.
Yes.
What are your views on using supervisory interdicts in order to ensure that, firstly, government does its job, and secondly, that it does its job properly?
It is a very useful tool which the Constitutional Court has, and the High Court as well, have used time and again. And well, let me say 99% of the time it has worked, but we do know that there are a few cases where, I'm just trying to remember now, a case from the Eastern Cape, I think it's Ndlambe municipality, but it involved the removal of effluent by this municipality. And there was a structural interdict granted, but we did not get the outcomes, the outcomes that were hoped for. The case of cash paymaster, SASSA, the payment of social grants, there were niggles there, and I remember that the CJ wrote an angry, almost angry former CJ, an almost angry judgment about how the court order in that matter was being treated. And there are others, but as I say, in maybe even 99.5% of the time, structural interdicts do serve the purpose they were intended to serve.
All right. Thank you, Justice Meyer. I just now want to put very briefly to you some of the, and I'm not going to put the actual objections, just an essence of some of the objections that we've received, just for your response. The first relates to a complaint about lack of transformation in the appointment of SCA personnel during your tenure. There was a complaint raised that you were appointing exclusively white personnel despite the imperative to transform.
Yes, Commissioner. Well, let me make the point first that I don't appoint administrative staff at the SCA. There is policy, as I indicated in my response. We have an equity policy that is derived from the DPSA, and it sets out the procedures that must be followed when we in the selection of staff. And judges, judges do participate in that process, but it's a process that's facilitated by the Office of the Chief Justice, the Human Resources Department in that body. And judges, I will be asked, I'm always asked to have a judge or 2 or 3 to participate in those processes, and they do. It is not true that the SCA General Office is predominantly white. I mean, this gentleman who raised this complaint got his facts wrong. Yes, we had the just recently left registrar, Mr. Mayberg, but Mr. Mayberg came to replace, in an acting capacity, a black male registrar, Mr. Mashinini, who had left at short notice. We literally borrowed him from down the road from the High Court. He was a registrar there, in an acting capacity, just to to assist us until we could find, what is the terminology? But we could find a permanent registrar, and he ended up staying. I'm just going to mention the names that are mentioned by this person first. He mentions Mrs. Van der Merwe. Yes, she is a white woman who was our chief registrar, and she had got the job on merit and experience. She was from the local, by highly experienced person who was excellent for the job, and she stayed with us until she left for greener pastures. And those are the only 2 white staff members I am aware of. Miss Geraldine Martin is a colored woman. She's black. She classifies herself as black, but for the benefit of this gentleman, she's a colored woman from the Cape Flats. She's a black woman. She's the director of the court, the first director in that court. The office is fairly new, and she was the first incumbent. Miss Carmen De Vie who's taken over from Mr. Mayberg is another black woman. She's a colored woman. So I'm not quite sure what the issue is. And yes, I do have the lady who's my office manager, the office manager in the president's chambers, Miss Sonika van der Walt, is a white woman. My secretary, she's not my secretary as this gentleman claims. My secretary is Mrs. Nyosana, who's been my second secretary in the court. I've only ever had black secretaries at the SCA, and broke the mold actually, because when I first came to the court, 99.9% of the secretaries were all white. Only Justice Cameron had a black secretary, and I insisted, junior as I was, to get my own black secretary. In the general office to which this gentleman refers, there's only one white person. In the entire office, Mrs. Liz Vermeulen, that's the only white person. So I'm not sure where he got his statistics from, unless he is telling us that white people have no place at the SCA, they cannot be employed if they qualify for the job, not just at the SCA, anywhere else in this country. The people, the white people who have been employed in the court, who are in our employ, qualify for those positions, and they're South Africans.
The second stream of objections, Justice Meyer, and I'm just going to lift the essence of the objection for your comment, relates to lack of reasons for dismissals of applications for leave to appeal and applications for reconsideration. You've already touched partially on the difficulties with Section 17(2)(f), but we've received a number of objections that seem to center around the fact that when litigants apply either for leave to appeal or for a reconsideration, and when these are denied, all they receive is a decision with absolutely no indication as to the reasoning behind the decision. And that's like a cluster of complaints that we've raised. Yes. Would you like to respond to that?
Yes, Commissioner, thank you for raising that issue, because it's something we get asked about everywhere we go. I remember Mr. Nokesi and his colleagues had invited me to address Nadel a few years ago, and that became a hot issue. The SCA does not, as a general rule, does not provide reasons in applications for leave to appeal, least of all for practical reasons. And let me just say this, the Constitutional Court has actually endorsed that practice. It is, if we did that, Commissioner, the whole system would grind to a halt. If I get an average of 5 to 12 applications for reconsideration applications per week, then it means I would have to stop everything and just deal with the reconsideration applications and write judgments in those matters. So it's just not possible. And as I say, and this is something the Constitutional Court has said previously and alluded to recently in the case of Lishing, that issues of practicability must be considered when this lamentation is made. So we don't. But that litigant, the litigant who's not furnished, who's just given an order that says leave is refused, that short sentence, is not prejudiced at all, because in 100% of the matters, there will be a well-considered judgment of the High Court, and in some, it will be a judgment of a single judge, a judgment of the full bench or the full court. So there'll even be two. I mean, one, the lady, the Miss Shelley Ecker, who raised the issue among these objections against my candidature, had the benefit of a judgment of a single judge and a judgment of a full bench comprising senior colleagues in the Western Cape Division. So there's no prejudice at all. And the law provides an option. If they're disappointed at the SCA, they can proceed, approach the Constitutional Court and have their, which incidentally also does not provide reasons in most of the applications. So that's my answer.
Thank you, President Meyer. The third and final cluster of objections, I'm going to generalize what they relate to. And it seems to be candidates who are prejudiced by shortcomings in the administration of the SCA. And one of the examples is where, and there were multiple accused, they were all convicted, and there was leave to appeal by one of the accused, who erroneously cited all of the accused as appellants, and when an order was granted, the order also was made against all of the accused, even though not all of them were applicants. And obviously the accused were not applicants, felt prejudiced by that because they now had an order against them. So what I think I would like you to address, Justice Meyer, is not so much the merits of this particular matter, although, I mean, you must feel free to touch on it because it was raised as an objection, but dealing more with the systemic issues. What happens when there are failures in the administration of the SCA? Firstly, who is ultimately responsible for that, and how are these systemic failures fixed?
It's a perennial problem, and I'm going to embarrass us. Some few years ago, we had an appeal in the matter of those matters that involve former NDPP Nomgcobo Jiba and Mr. Lawrence Mkhwebi. And it transpired long after arguments have commenced in the hearing that Mr. Mkhwebi was actually not represented in court. And the reason was simply that he had not been furnished with a notice of set down by our registrar. We have had these problems, and I don't want to name names, but we've had problems in our general office for a few years now, even when we still had a registrar and a chief registrar, despite their best efforts. It's a bigger issue, the environment, and issues that the OCJ should have addressed years ago. They know about, and a statement that was issued by the OCJ recently concerning the mishaps that arose concerning former President Zuma's matters was alluded to earlier. And part of these issues, and in that statement, actually, the official consent did consider that it was their fault that these issues, are not being solved. What we've done as judges, DP Petse and I, is to try and, while the OCJ is dithering and not doing their work, we've tried to implement our own measures to ensure that the work of the court, carries on unimpeded. And we created the office of office manager as part of that strategy. And this office manager, who's a qualified, she was an attorney before she came to the court. She was a senior, she was a law researcher, justice law researcher of many years before she came to the office. So she's someone with a lot of legal experience. But she had worked as a judge's clerk in the High Court and is very familiar with the processes in the registrar's office. So we were lucky to have someone like that. And we put her in my chamber specifically she runs a parallel general office in my chambers. We have 2 registers, and it caused a great lot of consternation from the registrar and chief registrar when we introduced it, because I said every little piece of process that is filed at the SCA and correspondence that goes out of the SCA must go through my office manager. As I say, she's running a parallel registrar's office, but unfortunately she can only do so much because she has other work to do, to fulfill the actual job description of her position. So you will find these slips through the cracks on occasion. And I put the blame squarely at the door of the Office of the Chief Justice, Commissioner Pillay. Yes, I'm the ultimate person, the ultimate responsibility for the court rests on me, but Lord forbid, I'm not a registrar. I can't go and sit there and leave my desk to go and check that DPP Downer in KZN has sent process to the SCA in April, and is only brought to my chambers on the 17th of May. I don't have that capacity. Literally thousands of court process is processed by this court on a daily basis. And there are people who are employed to attend to it. Mine is just to receive things from the registrar's office, allocate work to the judges and myself, and we do that work. I can't do both. So the blame, I shift the blame squarely to the Office of the Chief Justice, and they must fix it. And they've promised to look into it, as I said. And we will actually, at a recent Judges General meeting that we had a couple of weeks or 3 weeks ago at the SCA, we resolved that we are going to prepare a full memo about all these things that have happened down there and present a memo to the Chief Justice. So we are working on it in our own way. And I must apologize. It's terrible. I mean, many litigants have asked for expedited dates, and you find that the registrar simply did not send the documents up. Matters are ripe for hearing, and despite our best efforts to check, just to try to keep track of matters that are ripe for hearing and should be enrolled for hearing, some will slip through the cracks because we can't do it all. So those are things that we expect the Office of the Chief Justice to attend. They must do their work they are paid for, and we'll do ours.
Thank you, President Meyer. Thank you, Chief Justice.
Thank you very much, Commissioner Pillay, and thank you for dealing with the objections. Follow-up, is that Commissioner Malema? Oh, Barnett. Okay, Commissioner Malema, you must forgive me today.
No problem today.
Commissioner Barnett.
Thank you, Chief Justice. Just on the second line of objections, good afternoon, President Meyer. On the second line of objections, which had to deal with the lack of reasons, and you sort of pointed to the fact that it's not expected to give reasons and so on. But my question is this: does that not sort of open the applications for leave to appeal and also the reconsideration type of applications to a arbitrariness or to a lack of accountability? And I say this for the following reason. There was this King versus the Jager judgment of the Constitutional Court in February last year, where I think it was the majority and the minority. So the majority was Mhlantla and the minority was Justice Jafta. And both of them referred to a certain instance which wasn't granted. It wasn't leave to appeal or reconsiderations, but it was the lack of judgment that had been given by the SCA. And they were quite critical in I think Judge Jafta said that or both, Judge Mhlantla referred to Judge Jafta's judgment, and he quoted Mfahlele, where the court affirmed the principle and stated that there's no express constitutional provision which requires judges to furnish reasons. But then, and I'm not going to quote the long quote, but basically it amounts to this is the way that the judiciary is accountable and the rule of law takes place, and it prevents arbitrariness. So yes, one understands the volume, but is that an excuse to not be accountable? And isn't this something that should maybe be rethought on various levels?
Yeah, the system is not perfect, Commissioner. Ideally, a litigant should be provided with reasons on each occasion they go to court, and we get full-blown applications seeking the relief that they do in these matters. But there just is no capacity. And as I tried to argue earlier, there is an ameliorating fact that when a party seeks leave, they will already have the benefit of a fully reasoned judgment of the court ACO. And it obviously, the fact that the court from which leave is sought says no, must mean that the court agrees with the judgment to a large extent, or if maybe there's one aspect with which the court does not quite agree, it would not make any difference to the result anyway. But there will always be a fully reasoned judgment at hand, which this party can take to the Constitutional Court and make their case there. But if you have answers for us, I would gladly adopt them. But as things stand, we just don't have the capacity to provide reasons in petitions as we call them. We just don't. Otherwise, we'd have to stop all our other work and deal with petitions. And I don't think that would serve any purpose, really.
I think the point, just in closing on this point, is that the point is, I suppose, that's something which perhaps the judiciary can take into consideration going forward, you know, on that colloquium and that sort of thing.
Yes.
Yeah, thank you very much.
Well, maybe employ more judges, because we are inundated, terribly inundated with work, as you well know, as we hear all the time. So.
Thank you, Commissioner Barnard. Unless somebody feels very strongly, I would propose to only exhaust the ones that I still have. I still have 2, 4, 5 more to go. Unless somebody feels strongly that they would still want to ask questions, if it's fine with everybody.
I give up my position, Chief Justice, to make your life easy. I give it up.
Thank you. Okay, the ones I have. Yes.
Me too, Chief Justice. Is Dodovu?
Okay. Hang on one second. Yes.
I'm saying that I also forego my opportunity.
Thank you very much.
I've made up my mind.
We are. Okay, thank you very much. Okay. Yes.
Chief Justice?
Yes.
Same with me here.
Oh, thank you very much.
The online commissioners.
Oh, Professor Slema is the same as well?
No, I would like to have a question.
Or you'd like an opportunity?
I would like to have an opportunity.
Okay, I will put you here.
I would also like an
opportunity.
Okay.
I would also like an opportunity, Chief Justice. It's Glynis.
Okay, thank you. One sec.
The real Malema, Chief Justice, the real Malema on the line here.
Prove it, Julius, prove it.
Okay, thank you. I just want to, okay, let me tell you who I have now, and then maybe we would know that that's the last lot. I've got Commissioner Tsepe. Oh, she said she's foregoing, yeah. Okay. Commissioner Klaba. Then I have Commissioner Shabangumdawe. Commissioner Dodov has withdrawn. Oh, she has also withdrawn. Okay, thank you. Then I just have Commissioner Klaba, Commissioner Slema, Commissioner Malema, Commissioner Breitenbach. Okay, all right. Commissioner Klaba.
And Commissioner Barnard as well, please.
Oh, okay.
Thank you very much, CJ. Good afternoon, President Maya.
Good afternoon, Commissioner.
Thanks. I want to refer to this transcript of your interviews in February this year. I'm on page 26, paragraph 15. You correctly characterized an evenly split judgment with no decision as an unfortunate phenomenon. Following the evenly split decision on the bail application, just recently, in a Mafe case, it's in the Western Cape. A colleague of mine asked, why is the stalemate not anticipated? The decision, I think it was on Tuesday, it's a bail application on Tuesday, and because it was a split decision, the matter was going to be reheard 6 days later. Remember, we're dealing with a bail application. The person is still in prison, and he would wish not to serve another day. And what is your comment on that?
Those are two different scenarios, Commissioner. The example of the Constitutional Court is caused simply by convening an even-numbered panel, and it could be easily resolved by convening an oddly numbered panel, and then you won't have a situation where there's no ratio of the court. Now, I'm not quite sure I follow the question concerning what happened in the Western Cape. Are you saying that, just explain to me, how was the bench composed?
It was a two-member court, and the decision was split 50-50. And it had to be reset for trial 6 days later.
I see.
And it's a bail application for that matter.
It's the same phenomenon then, Commissioner. This evenly balanced, this evenly composed, even number composed panel. If you have 3 judges, for example, then you'll have a majority decision which binds everybody. That's the point, the simple point I'm making.
But the question is, President Maya, why is the stalemate, that was the question, not anticipated, that a two-member panel was instituted?
I'm sorry,
I'm asking this question in general terms.
I understand. It should have been anticipated, Commissioner. And in my defense, the SCA always sits in odd numbers. And in the case of petitions where they are allocated to 2 judges, if there is a difference of opinion, then you rope in a third person, and that breaks the impasse. So it's something that we should all guard against, I think. But the solution is very simple.
Thank you. And then the second question, Chief Justice, with your indulgence. You currently occupy the highest seat in the appellate division. And,
yes.
The appellate division is the final court of appeal in certain matters.
Yes.
All right?
No, not in certain matters. Remember, the ConCourt, the Constitutional Court has general jurisdiction now, but we have the final say only in a practical sense, because many of our judgments do not proceed to the Constitutional Court.
Correct.
So that gives us, but the same thing happens in the High Court as well. Not all their decisions are appealed against the SCA.
Correct. Now, to that extent, your court was immersed in the transformative constitutionalism, let me say, project, okay? I wanted to ask a question. Are you satisfied with the speed at which the project is pursued in our country? I'm asking, maybe to be specific, are there any matters you consider as sticking points that which non-resolution or a delay in resolving them may have the effect of creating despondency in our society?
Well, first, I don't think any of us are satisfied with the pace at which we are driving the injunction, the main injunction of our constitution, to create an equal society where everybody enjoys human dignity, but that's the challenge we face and need to do something about. There are a whole range of cases come before courts, and to all those litigants, to every person who approaches the court, their case is the most important. But we have to acknowledge that there are cases, and there are cases, they vary in their agency. And we know what the most serious challenges are in South Africa. I mean, matters that have to do with socioeconomic issue that speaks for itself. That matter has to be urgently disposed of. GBV, all these cases, that involve offenses committed against our children and the vulnerable of our society, mainly children and women. Those deserve speedy resolution. There may be other classes as well, but these two, readily come to mind. Oh, and there's going to be another class now, Commissioner. We have heard that there's a threat of a flood of corruption-related cases that will be coming to our courts. I imagine that we will need to do something about those quite quickly, because South Africans are demanding a resolution of these matters on a daily basis, on social media, all mainstream media, everywhere. People are complaining about corruption and the fact that nothing seems to be done about it.
No, you have covered my follow-up question. Thank you very much, CJ. Thank you very much, President.
Thank you, Commissioner. Commissioner Schlemmer.
Thank you, CJ. Good afternoon, President Meyer.
Good afternoon, Commissioner.
One or two questions for you, and that relates partly to some of the answers that you gave during today's.
I'm sorry, Commissioner. I'm struggling to hear you. I wonder if you're not too far from your mic.
Is that better?
Yes.
Okay. I would like to know from you, during the course of today's interview, you mentioned that the reason why you wrote the judgment in isiXhosa was because of me. And my concern, in essence, with that particular response, and in relation to some of the other questions in previous interviews where you said on a question that I posed, the fact in the SCA that sometimes things are taking long, sometimes judgments are wrong, you said we are trying. So basically, your response is, from your perspective, you are trying. When it came to the judgment in isiXhosa and the fact that even JP Liu asked you, why didn't you write that judgment then in Afrikaans, because of the participant or the litigant in that particular case, you said it was because of me. That's why I wrote the judgment in isiXhosa. It creates the impression that sometimes you allow your personal feelings to come before objective judgment. Am I incorrect in saying that?
I was hoping that at the end of the interview, the CJ will give me an opportunity to explain, or, I did not express myself properly when I gave that answer. Yes, the me is part of it. I'm a human being. That's just our makeup. But the main and more important reason was what I've mentioned, the issue of cultural identity and promoting, fulfilling this demand to promote all our languages in South Africa. And I could not just have written an isiXhosa judgment for me, just for my own appreciation and admiration, Commissioner. And I'm sorry that was a very clumsy answer. But the real reason actually was this I'm looking for the English word now, but this message that Commissioner Mutsecha and other commissioners of his time had been constantly driving that, but what are the courts doing about promoting issues of culture, language? So that's what prompted me, but it was a matter of great pride for me as well, I have to admit that, to be able to produce a judgment in my own very beautiful and downtrodden language. So that's the best way I can explain it. Yes, there was an altruistic motive, I'm not gonna deny that, but there was this other, lofty ideal I wanted to push.
Thank you. The other thing that I would like to hear from you, there was talk about the heads of court cluster and some decisions that are made there and policy decisions made there. And linked to that, your participation in the head of courts cluster. We were told, it was written in the report on the judiciary that I have questioned many applicants before on the fact that the heads of court cluster decided that judgments need not be scholarly any longer. There was also a decision made by the heads of court earlier on under the previous CJ that the language of record is in English. And all those type of decisions, policy decisions, it seems, made at the heads of court cluster have an impact on the judiciary as a whole, has an impact on, I think, also access to justice. Saying that the record of the court is only in English, whereas we know that the rules of the Constitutional Court allows for the parties to address the Constitutional Court also in other languages. But also the issue of scholarly judgments not required anymore also impacts access to justice to an extent, also the training of lawyers. What role do you see that you will be playing in this head of courts cluster if you are going to be part of it? And if you're not going to be part of it, how do you see this role and how do you see writing of the isiXhosa judgment? Is that in conflict with that policy decision? It's obviously not in conflict with the Constitution and what we should be doing. So that seems to be like a total kind of a dichotomy that one sees when I look as an outsider to the head of courts cluster, what the policy decisions they make, the impact that it has on Joe Block and everyone in society, and also then on the people on the bench. I would like to hear your response to that, please.
Yes, Commissioner. First, on your pet question of scholarly judgments, I know of no policy decision of the heads of court that said it's fine to produce judgments that are not scholarly. You and I don't quite agree on this subject, I suspect. My view is this: there's only one way of writing a judgment, Commissioner Schlemmer, and it's what we are taught, the FIRAC approach that we are taught at university. There's no other, and that to me is scholarly enough, because then it encapsulates everything that's essential to be contained in the judgment. So, and I think I've even asked you at some stage what a scholarly judgment is, because I'm not quite sure I understand. But a judgment that follows that IRAC rule, that time-honored rule, is the judgment for me. And I'd like to, at the risk of coming across as immodest, that's the approach I've always followed. And I'd like to think that I've written some fairly good judgments following that approach, and so have my colleagues. But important part is that I don't know that the heads of court decided that it's fine now to write judgments that are not scholarly, whatever that means. About the issue of language policy, let me just say this: that decision, the judges were not consulted about that decision. Let me just put it that simply. And you will recall that I'm the first person to lament the fact that judges have not had a colloquium in all these years, despite all the important developments that have taken place in and around the institution. And it seems to me that that is a subject, actually, that's a perfect agenda item for that kind of gathering. Where it did not happen. I won't say more on that. All I will do is to just highlight the fact that despite that policy, I wrote a judgment, a bilingual judgment. And despite that language policy, we have seen bilingual judgments coming from the Constitutional Court itself. So that's the best I can do for now, for here and now.
Thank you. Just one follow-up. When you say that you're not aware of a policy decision about the scholarly judgments, it was reported in the State of the Judiciary report that was presented to Parliament by the previous CJ in a couple of years ago. I can send you the reference. I don't have the reference on me at the moment, but just that you are aware of it. It's out there in the public.
Honestly, I'm not aware of it. It slipped my attention. I guess I was remiss, but okay. Yeah.
All right, just one follow-up on what you just said about the policy, the language policy. It occurs to me that earlier on, and I can't recall who the candidate was, but it was a couple of years ago when I was not a member of the commission. You asked an applicant or a candidate for the SCA why she wrote a judgment in Afrikaans at the SCA.
Yeah.
And it created the impression that she was wrong in doing that. And you didn't correct her in any way by saying that English is not the only language that can be used. Why did you ask her that question? And why didn't you correct that impression that went out there, that you were actually kind of criticizing her for doing that?
I have a sneaking feeling that the record will bear me out, but I would have explained to the candidate when I posed the question that it was a concern that came from members of the court, and that's what we routinely do, to ask questions that have been raised by presiding judges who sat with the candidate or other members of the court about matters we think are important. And the issue with that particular matter is that the judgment was only in Afrikaans, and a great number of judges themselves, let alone the South African public, do not speak Afrikaans. I am not entirely sure if the policy of this English as the language of record policy had already been passed by at that time, but the practice in the court actually was to write in English. And even I remember there's a colleague, I won't name him, there's a colleague who started this practice that even where you made reference to Afrikaans or other language text, you would have that in the main body of the judgment, the original language, be it Afrikaans or whatever. And then in the footnote, have an English translation. And I remember this was actually discussed at some gathering of the SA judges. And so it was pertinently raised that our judgments actually are read, far beyond the borders of South Africa, where people don't speak Afrikaans. I remember that there's a colleague, Justice Lewis, who got massive recognition from an American university for a judgment she had written, and we were all very proud of that. So that was the point that was made, that this is a senior national court, which has influence outside the borders of this country. So we'd like all our judgments to be understood by every reader out there. And I thought that rationale was good and innocent enough, Commissioner.
Thank you, Chief Justice. Thank you, President Meyer. I would just like to see that if you were to be appointed to this position, that the issue of translating judgments be also discussed at the judges' colloquium, because otherwise we are just not doing what we're supposed to be doing. Thank you very
I
much.
fully agree with you. Thank you, Commissioner.
CJ,
Thank you,
follow up.
Commissioner Schlemmer. Commissioner Malema.
CJ, may I make a follow-up on the last issue?
Oh, okay. Judge President Lee, a follow-up?
Yes, thank you, President Maya. When the decision was taken as a policy decision by the heads of court, you were part of that decision at the heads of court, but you never raised an objection. Is that correct?
Which decision, JP?
The policy of the language of the record, the court record. And I remember in that meeting, the motivation was, if a record comes from the High Court and it's in Afrikaans, and it has to go to the, on appeal, you find that on the panel, if the record is in Afrikaans, the presiding judges, some of them don't even understand Afrikaans. So it meant they had to employ people to translate the record, and that was cost effective. And number two, it took long. And the issue also was raised that the translator that they had employed had not done, they were not doing the correct things, because I remember even the issue was one record was even translated based on Google. So those were the record did not make sense. So it was just for practical purposes, but not that you cannot have a properly translated record.
So what is the question, JP?
My comment to you is you were part of that decision. When you say you are not consulted, but you were part of that decision and you never objected at that meeting.
I think I've said all there is to say about the language policy, Chief Justice. I have nothing to add to it.
Okay, Commissioner Malema.
Thank you very much, Chief Justice. Good afternoon, President Maya.
Good afternoon, Commissioner.
I just want to ask about the leakages in courts. We have a big problem, and it doesn't enjoy much publicity, but there's a problem of leakages in the Gauteng High Court, the North Pretoria, and the latest being the one at the Constitutional Court, and the manner in which it was handled. To a point where we only had that there was an investigation when an announcement was made, but it was not as transparent as to give the confidence that indeed this matter deserves some attention, or is receiving some attention. What's your take on leakages in courts, and if appointed, what will you do to make sure that there are no such leakages, especially at the Constitutional Court? Thank you, CJ.
Yeah, it's an extremely serious problem, Commissioner Malema, that just should not happen. And I think I speak for all judges, at least, when I say we were just shocked, but especially by this last one affecting our Apex Court. I mean, these things never happened in the past. It's a new phenomenon for us, at least, all together. Look, I know that we should not take any comfort at all from the fact that it does not appear to afflict us only. Just around the same time that the Constitutional Court scandal erupted, similar thing happened in the US of A, with at least there with dire consequences, because the public, came out. They would not stand for it, and South Africans, I suppose we have too much on our plates as it is. We can't be bothered. We were bothered, but not all that much by this scandalous event. I'm not entirely sure what else can be done to ensure that it does not happen, that the courts are not doing already, because the only people who are involved in the preparation of judgments will be your judges themselves, the secretaries or whoever types the judgments, the law researchers, the law clerks, and there are prescripts in not confidentiality. It comes with the job for judges, so that you don't need to say anything about that. But for the staff, in the HR prescripts, there is something that binds them to confidentiality about work of the court. Now, if they are the culprits, I don't know. If people are not going to